What I'm going to present here are two opposite trends that are going on right now in Argentina, which is on the one hand, a very progressive case law. I think that in Argentina, we have like the greatest number of rulings favorable to animals. We have more at this point than 15 or 14 case rulings declaring some animals subjects of rights or recognizing them some rights and freeing them. But at the same time, we are enduring the intensification of animal farming. And our economy and identity and history and our role in international international trade is based on animal exploitation and agricultural activities. Although right now, as I'm going to mention, our economy is based more on soybeans to feed Chinese pigs, we still heavily rely on meat production, and red meat has a strong symbolic power in our society. So these two trends, which are of course at some point incompatible, need some analysis for many reasons. One is like to, for instance, take into special consideration that this background, this scenario where the meat is so important, is an aversive scenario, but despite, and we are going to find even rationales based on the legitimacy of this activity while recognizing animal rights and how judges navigate this opposition. But I think that we also have to pay attention to this, because every time we think about animal rights, we need to pay attention also to contextual or particular features of each country or region to like start thinking about how to achieve this in the legal realm. On the other hand, I think these opposite trends and the surprisingly amount of favorable rulings for animals can be in part explained because we have a very strong animal rights movements, which can be also related to like a very strong tradition of social movements in Argentina. We already have a strong tradition in human rights achievements, and a very also strong and social-environmental movement. And I think that's why we have a strong animal rights movement too, which is very also national-based, although in the last couple of years, some international NGOs started to have more influence, and including some discussions that I think that are not the most appropriate for the country, but this is beyond the scope. So how I'm going to address these issues? Well, this presentation is divided into 6 sections, and please don't worry, they are going to be short, or I will try to do them short, especially the first 3. So the first section is about the red meat importance in the country and some very brief historical perspective about it. The second one is an exploration of the legal framework, mainly based on the legal framework chosen by judges in these rulings and animal lawyers, to provide also some critical analysis about it. The third one is about animal welfare regulation, because one could be tempted to think that animal welfare regulation should be part of the legal framework, but we will see that in this case law, although it's mentioned and it's often overlooked, these mentions to animal welfare to based animal rights, it's mainly unknown by judges and unknown also and rejected by animal rights lawyers and animal rights advocates. The fourth section, it will be about some of the key victories of animal rights movements, which I think are the background and part of the explanation of these rulings. In the fifth section, I will describe the principal rulings and some of the rationales in a very first, at the very first level, in a very descriptive and simple way to highlight the rationales. This is it's a very rudimentary way of thinking about the case law, but to highlight the main rationales. And for instance, I was looking for nature's right, and because now it's a trend thinking about nature's right or aboriginal cosmovision, and I was looking, and I was also surprised to detect mentions to animal welfare and to some other key points that I'm going to highlight. And in the sixth one, I'm going to explore more robustly the Judge's rationales. Also to, if I have enough time, to share with you some ideas about what I think could be like the, maybe a more interesting path to approach this kind of patchwork judges are doing when deciding to free or to recognize animal rights or animal legal personhood. So if I have time, I will go deeper about this. So I think it's a lot of information, so I'm going to try to make it a quick description, but also try to connect the dots of what I'm thinking, like more theoretically at the end of this case. So as I said, our international role since independence has been exporting agricultural commodities. Unfortunately, this has had very bad economic consequences, and this is still the case in Argentina. There have been attempts to change this model, but these attempts were not successful, and we still rely on the agricultural export sector, which is very strong also politically. But right now it's mainly dedicated to producing soybeans to feed Chinese pigs. Red meat consumption is the highest per capita in the world, in Argentina. It's part of our identity. Asado, which is a kind of barbecue, it was the original diet of the gaucho, a mythical figure of our national identity. And so it is still the most traditional dish we can find in Argentina, and other dishes are also based on red meat. Red meat is so important in the country that even it is part of public policies, and governments throughout the history have been navigating the need to export and have dollars from meat exports with the need to control the prices, because not being able to buy red meat cause population discontent. So it has that kind of importance. Even more when population cannot buy as much red meat as they wanted, they start increasing the consumption of other meats like pork and pig. So I think that this is a very aversive background to consider animal rights recognition, because we are living in a society that it's not only relying on animal exploitation. It's not only based its culture on animal exploitation, but also rely on animal exploitation, on agricultural activities more in general, to sustain its economy. So I think that's a very important thing to bear in mind. And this is going to appear in Cecilia, for instance, in Cecilia's ruling. What about the legal framework? Well, as for the legal framework, this is also part of the analysis of these 11 rulings that I review here for this presentation and for my work more in general. As we know, the the well-trodden path when we think about animals is thinking about a civil code, or about in the common law, thinking about that the law has two categories, things or subjects. And this is also the case in Argentina, of course. Unfortunately, we have a civil code that considers animals or categorizes animals as things. But and judges, as we will see, and also animal rights lawyers and animal rights advocates pay too much attention, in my opinion, to the civil code, and they also start their reasonings and their arguments in favor of animals by criticizing the civil code, which I think it's a mistake for the reasons I hope to have time to discuss in the last section. But fortunately, we also have another provision, which is in the criminal code, which is an act from 1954, which criminalizes animal cruelty and mistreatment, and which specifically refers to animals as victims, using this word. This word has been key also to put in to address the problem of the civil codes categorizing animals as things, because we have the civil code that categorizes animals as things, but we have the criminal code categorizing animals as victims. We also find in these rulings mentions to the national constitution regarding environmental protection, even as a human right, the human right to a healthy environment. We have signed many human rights conventions. We are part of the OAS. We can find mainly in these rulings environmental laws from the state level to the federal level. And we also have mentions of three non-binding declarations, which I think it's very interesting to mention. Not only out of curiosity, but because I think what's going on here is that judges and also animal rights lawyers are in desperate need of positive law when we are deciding. And they think that there is not enough positive law, and so they go to the resource to these declarations. And I'm speaking about the Universal Declaration of Animal Rights that is wrongly said to be adopted by the UN and UNESCO. This can be found in the rulings. The Consciousness Declaration of the Cambridge Declaration of Animal Consciousness, and the Toulon Declaration of All Living Things. There are, I think, two declarations, and this is one. This is the one that appears in any of these rulings. So we have, on the one hand, this trend of intensifying and relying on animal exploitation. We have a very weak constructed legal framework, and we have animal welfare regulations that are mainly unknown. It's a developed area, and I set this animal welfare regulation aside from the legal framework because it is not used in the same way that it is used, and I think it's a mistake, in the same use that the other provisions are used in the case law. These are mainly administrative resolutions by SENASA, which is the national office that regulates animal products for human consumption. It's mainly unknown by judges and rejected by animal advocates and animal lawyers because they think that to embrace this kind of argumentation, it's like also to embrace welfareism. But interestingly, these regulations already recognize animal consciousness, animal ability to feel pain, distress, pleasure, and to suffer. So I think we could advance in my ideas for the sixth section. I would say that it is a mistake not to rely more on these provisions that we already have. It is true that these are mainly resolutions for cattle or for farm animals in general. We also have 2 acts that refer to animal welfare for other species, but in the end, we are all referring to domesticated animals, mammals. So this recognition could be extended to the other animals that have been part of litigations. So going to the main victories, which I think that are part of the explanation of these successful rulings, we can see that the first one that gained public attention in the mass media was 4 or 5 years ago, the campaign against the Buenos Aires Zoo that finally was closed. This campaign was very important because it also started the trend to close in other zoos and to change the law regarding zoos in the country, but also because it was in this zoo that Sandra was living. Sandra the orangutan which was like the first case, the first ruling favorable for animals in Argentina, and I think it was one of the most internationally renowned ones. And she was living there. And also, this was a very successful campaign because it also ended up in the closing of the Mendoza Zoo, which was the zoo in which was living Cecilia, the second case we are about to analyze. Another very crucial victory was the criminal punishment for dog racing. This discussion also reached a lot of public support. We had a very strong tradition on dog racing in Argentina, which was really bad for greyhounds. Finally, the criminal code was changed, and this specific activity has a very high penalty. So the activity really stopped in the country. And the third key victory, and more recent one, it was the victory against what is known as the China Agreement. The agreement with China to install intensive pig farms in Argentina. This agreement was made during the pandemic in 2020, and it was kind of a hidden agreement, but it reached the public attention because there was a very strong campaign against it, mainly thanks to an alliance among social environmental groups and some animal rights groups. The outrage was so big that the government finally decided to abandon this project. And 2 other mentions that I think are well worth talking about is that thanks to the strength of the animal rights movement, veganism reached also mass media, which is very difficult in a so traditional country. So difficult scenario when we think about these problems with red meat consumption I mentioned, and the movement reached to the mass media and to discuss this, and it was there were moments and interviews that were really important in very traditional mass media, and I think that's also very important to create a more progressive environment. And also there is this poll that was made by the Unión Vegetariana Argentina, which discovered that at least 12% of the population in Argentina is vegan or vegetarian. So a lot. And another 12% is flexitarian, apparently. So it's a huge amount of people. I think that's also in part explain the situation. So, which are the case law I'm interested in examining with you right now? Well, I'm going to be quick I think I still have time. Of course, the first one is Sandra. I think that we don't need to pay too much attention. I think we all know about this case. This was part of a deliberate attempt to free an animal and to reach a favorable ruling and the recognition of an animal as a subject of rights. It was successful. It was a long quest to get to this ruling. But what I'm interested in what is interesting in this case, I think it's that animal welfare appears as a concern to liberate or to free this animal. Another remarkable thing is that this is the only ruling where nature's rights and Ecuadorian constitution are mentioned as part of the foundations. Among the 11 cases I'm going to describe, this is the only one that mentions nature's rights. And also there is a mention to the civil code as a problem to recognize Sandra as a subject of rights, but also there are five mentions to the civil code. So it's based also in part in the civil code in the provisions that prohibit the abusive exercise of rights. So I think it's interesting that the judge found also in the civil code elements to consider Sandra subjects of rights and to free her. The next or the following case, only a year after Sandra's rulings, was Cecilia's case. And Cecilia's case was also part of a strategic litigation by a father, the same NGO that filed the habeas corpus for Sandra. But what is remarkable in this case is that this was the only successful habeas corpus, I think internationally, because there was another one in Brazil, but unfortunately the chimp was dead before it could be released. So in this case, the judge accepted the habeas corpus, and this case took place in this zoological transformation scenario and this heavy campaign against the zoological institution in general. So there are 4 mentions in this case to animal welfare, and what is often overlooked in this case law is that, for instance, in this particular ruling, animal welfare was one of the main reasons why the judge considered that Cecilia should be free from the zoo, and that she was and that she has rights. So this is interesting because the traditional opposition between animal rights and animal welfare, I think it's not part of the conversation, at least for judges in this case. The other thing is that there is a reference to this Universal Declaration of Animal Rights, that we know it's only a proposal and it was never adopted, and it's a problem because judges are sure that this is like something that was adopted by the UN and UNESCO, and this is a mistake, of course. There are 3 references to the civil code, which is not so much taking into consideration that this is a 60 pages or more ruling, very, very long and hard to read, I must admit. It's not very well written. And there are more than 30 mentions to environmental provisions and also environmental case law, which is very interesting because in the end we can trace the main foundation of this ruling in environmental laws. And this is a problem, of course, for many reasons. We already know that. But I want to highlight something from this case specifically that I'm very interested in, and which is the same thing that happened in Estrellita's case. We have seen that these 2 judges are defending animal farming, So specifically, she quoted a previous environmental case law very well known in Argentina, Catan ruling. And she relied on this differentiation that judge made between cattle raising and protecting wild animals. And the second group of animals, wild animals, have cultural value, and that's why we are protecting them. So this is interesting because it's not a matter of environmental balance or ecological balance, but a matter of culture. While for these such as cattle, sheep, pigs, and commercial fishing has no cultural value, but it's kind of difficult to follow the reasoning in this case. But I want to mention this because in Estrellita case also was strongly and explicitly defending the right to farm to eat animals, as in this case. Then more rulings, to analyze. And I think that what is interesting in these rulings, that except for the last one I'm going to refer to, they are not part of deliberate strategies. They are all the result of animal cruelty cases that reached the court just by chance because someone made a complaint or the police arrived to a place and find an animal, but was not the intention to protect or to take care of that particular animal. So these are a series of rulings that reach court and favorable decisions just by chance. No NGOs or no animal rights advocates were working on this, but despite this, the prosecutors and judges declare these animals animal subjects or animals with some rights. So the first one in 2015, also the same year of Sandra, and an animal cruelty case against a hoarder. Dogs were declared subjects of rights. There were no mention of environmental laws. There was a reference to Sandra, which is the case that all judges refer to. There is a mention to the civil code, no mentions to other declarations or animal welfare. Then we have another less known criminal case, but which was very important because she was a mare, Gitana, who was pregnant and who was being exploited in informal urban trash collection. The man who had this mare was prosecuted for animal cruelty, and this case is interesting because there is a long discussion about animals not being things, but at the same time using the civil code to not to assert that this man couldn't prove that he was the owner of this mare because he didn't have the papers for it. So it's kind of tricky. And there was also discussion about the procedure, the criminal code procedure for not returning the mare to the owner. So I think this is an interesting case also. And then there were two other cases that are remarkably for different relations, for different things. One is Coco's case. Coco is a monkey from a native species in Latin America. He was found by chance in a police raid, but living inside a closet with a very suffering from malnutrition and mistreatment, and of course this person was also prosecuted for animal cruelty. And Coco and the prosecutor asked the freedom of Coco and the declaration of legal personhood, and in this case appeared 4 times loosely mentions to animal welfare, never referring to the actual regulation, but as terms used to base these decisions. And there were also mentions to the Cambridge Declaration, to the Universal Declaration, to Toulon Declaration, to some sensitive cases, a discussion about the civil code, and a lot of discussion about environmental laws, which were appropriate because it was a native species of a wild animal. And yes, it's forbidden to have these animals in your house. Then we have another animal cruelty case, pit bull killed in a police raid during the pandemic. She was shot dead by a police because he said this dog attacked him, and the judge discussed animal rights. And it was interesting also because he, on the one hand, recognized that Tita was part of a multi-species family, which is interesting. And also he stated that animals have rights, although they are not the same rights as humans. They are not the same rights that we humans have. But in this case, there was no collision of rights, because the right of Tita to live was Tita was not really a peril to the police. She never attacked the police, and so the killing of the animal was unjustified. There is like this discussion about the balance between animal rights and human rights, which I think it's interesting. Or rights of human, not human rights in the sense of, in the technical sense. And then we have other cases, also another kind of hoarder of animals, and another wild animal kept as a pet in a house that was declared also subject of rights and free. But what is interesting here is that in the case of Lola Limón, who is a puma, is that she was sent to the new Ecoparque, which replaced the former zoological garden, and she's going to be under a reproduction program. So it's interesting and also upsetting that even though she was declared subject of rights and that she has the right to be free, she was sent to live in captivity for the rest of her life, and moreover to be part of an experimentation program. So this is kind of nonsense. And there were two more cases about horses, also a criminal case. The remarkable thing here is that the judge thinks that he must embrace judicial activism because the civil code is not updated according to the new case law, and the judges, he asserts, must change this or address this problem by issuing this kind of progressive case law. He also mentioned Toulon and the Universal Declaration of Rights, another resolution that I don't have time to talk about, but everyone knows it's a resolution and but it recognizes the dog as a subject of rights. And then there are other decisions about multi-species families that are interesting, but I have no time to include here. This is part of the essays, this horse case. I'm not going to read it. Also, it's very long, and one of the problems of these rulings in general is that they are like written in a very hard way to read. But what I'm interested in is in the last case, which is Toti's case. Toti is a chimp. This is the third case of among these rulings that it is part of this strategic litigation. This is the same NGO of Sandra and Cecilia filing a habeas corpus for Toti, which was at first rejected and transformed by the judge in an amparo, which is a constitutional action. Interestingly, this case, in this case, the first instance judge didn't want to say anything about the legal status of Totti. She said that it was not necessary, that there were a lot of environmental provisions that protect Totti. So we don't need to discuss his legal status. She was not going to say anything about Totti being a subject of rights or being a thing, because it was completely beyond the point. But nonetheless, she quoted civil law doctrinal authors and a Supreme Court judge who are opposite or who opposed publicly to the idea of the recognition of the legal recognition of animal rights or legal personhood. So I think that it was quite clear that she didn't agree with that, but nonetheless, she decided that Totti should be free from the zoo and should be sent to a sanctuary in Brazil. Unfortunately, the zoo appealed this decision, so the state Supreme Court had to and decided also in this case. The new ruling was pretty much the same kind of thing as the first instance ruling, again relying heavily on environmental law and not saying anything about the legal status of Totti, but also confirming that Totti should be transferred to a sanctuary in Brazil. Again, the zoo appealed this ruling, and now we are awaiting a national Supreme Court decision, which is very sad because it can take years to reach a decision, and we don't know what the court is going to say, especially because one of the judges is against animal rights recognition. So this is a very interesting quote. If you want, I can then send you the PowerPoint because it has nonsense. It's really upsetting to read these rulings about we cannot decide about rights because blah, blah, blah. I have no time, fortunately, to address this. But to recapitulate, in terms of species, these cases are about all wild species, native or exotic, and domesticated animals, but domesticated animals not used for human consumptions, because we don't eat horse meat, although Argentina exports horse meat hypocritically to the European Union. So we cannot eat horse meat, but we can export this. But these are animals that are not part of the they are not part of a big industry. And also, there are no rulings about other group of animals, like liminal animals, like, for instance, pigeons or animals living in our urban cities. So we are not, it's very, a very traditional division, wild animals or domesticated animals for companion. Then there were only 3 deliberate strategies that were the use of habeas corpus, only 1 successful, and the rest were all criminal cases, which is also at some point, at least to me, it's something to worry about, to use this path, although it was not properly used, but more like by chance. But I don't think that it's any favor for the animal rights movement to embrace the criminal code. And then we have that from all this ruling, except all changed the legal status, except for one, Totti, and they also all freed animals except for Lola Limon. There is also no mentions to nature's rights except for Sandra's ruling, so this trend appears not to be very important, at least in Argentina. There are no mentions to aboriginal cosmovision, another kind of trend that I'm detecting right now in the animal rights scholars' works. About the rationales of these judges, what I found it remarkable is that animal welfare is mentioned even to free animals or to base animal rights, which is interesting, and it's I think out of the box, at least, if we think that this traditional opposition between animal rights and animal welfare is like a huge part of the animal rights conversation and strategy sometimes. Also, there is a heavy reliance on environmental laws, even in animal cruelty cases, regarding, for instance, domesticated animals, which are not the original scope of environmental laws. There is a strong weight of the first case, which is Sandra, the first ruling. Sandra has a lot of weight in these decisions. There is, for instance, no mention to other international case law. Unfortunately, we see the mention of the Universal Declaration of Animal Rights, the Toulon, Cambridge declarations, the pervasiveness of the civil code to start the argumentation, and unfortunately, although we have a criminal code that refers to animals as victims, we have almost not mentions or more discussion about it. So to conclude, because I only have 5 minutes, and I think these are like very, 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 I'm going to share with you some ideas that really are some ideas that I'm going to share, to have some feedback. What I think we can learn from all this case law is that, well, there are things that we are not paying enough attention to. For instance, animal welfare mentions, but in a very loosely manner at first. We have provisions that recognize animal consciousness in our legal system, and I think it's a pity that judges or animal lawyers do not know this, to avoid this kind of Byzantine discussions about animals being or not conscious, having or not the ability to feel pain or not. I think that's pretty much solved if we push that interpretation of the law. I think I have that resource and we are not using it properly. And on the other hand, I think that another thing that we can learn, or we learn from this, is that much of the critique of this case law and the discussion around this case law, although it's a case law that we very much like because it recognizes animals as subjects of rights, on some rights, and of course it's very progressive, and it's the first step. I think it's that when thinking about it, I'm thinking about people who already embrace the idea of animal rights recognition, of course, like inside the movement. I think one of the problems is that we like very much critique this case law from an external perspective of the law, or that you can even see that when we are speaking about strategies. Which is the best strategy? The strategy, well, a legal personhood, maybe it's not the best strategy. What we should go for is for some rights for some animals, like a very progressive path from not a sum zero game, all or nothing, and thinking about this, or like addressing the judges' rationales by confronting the idea that animals are things with a lot of scientific evidence, with a lot of scientific, which is of course very important and is part of the rationales, and I'm not saying that they should not be part of the argumentation, but I think that we should change the point of view and embrace a more internal point of view. And instead of talking of strategy, from the outside, because it seems like we are kind of using the law.
Ahora que estoy,
Sorry, but it's like I feel sometimes that we are kind of using the law to help animals. But what about if we really embrace the law for what it has to give to us, which is like pretty much, for instance, in the Western world, we have the promise of the law to protect the weak, to achieve justice, to we think that the law is based on the principle of equality, that all human rights are equal. Wouldn't it be better, like, to start thinking about which principles we can find in the law, which provisions we can find in the law, not to speak about the law strategically, but to think, in our own legal systems, principles and values that are the basis of the law already are already there to include non-human animals. And I think that other discussions are kind of distracting: nature's rights, environmental protection, but also the idea of which strategy is best from this external point of view. So my feeling here, or my intuition here, is that we need to work more with the theoretical tools that legal philosophy has or have had for decades, to also to construct a more robust corpus of legal materials to help judges and animal rights lawyers when they face this kind of cases or problems or discussions, even at the parliamentary level. So that's one of the main ideas. And the other one, to close, is to think more contextually. And I think that that's important because sometimes I read papers or research talking from nowhere, like every situation were the same, and I think that I'm doing research in my country and about my country, but I think that every region, every country has its own particularity and particularities, and I think that we have to pay attention to that when we think about how to discuss animal rights. And that's pretty much. Thank you.